Hi. Just getting my notes out. Thank you so much for having me. This is a great honor, sort of a career-spanning honor, and you know, I'm deeply appreciative and glad to be here. I hope you can hear me. I'm told that I have to speak into this mic, so I'm going to be leaning over. I'll try to look conversational as I do it. So I'm going to give a talk today about what I call the dark matter of federal Indian law. And so I hope you enjoy it. There's a comic book. It's intentionally cryptic. So I haven't written this paper yet, but I hope to in the next month or so. I promised to write it for the Maine Law Review for a symposium, so I hope they take good care of it, assuming I finish it. Okay, so this is how I'm going to start. I'm going to say that those of us, I include myself in this, have historically suffered from a lack of imagination in Indian law, primarily federal Indian law. And what do I mean by that? So I came up as a tribal attorney for Indian tribes. I worked in-house for tribes. There are only a few of us who are now Indian law scholars who started their careers or spent any significant amount of time working directly for tribes. That's not really a career path that gets you into law teaching. Typically, you want to clerk for a fancy federal judge. You want to work at a big firm or do something highfalutin with the federal government, and then work your way into acquiring a cadre of recommenders, mentors and advisors who are themselves famous, and write you letters of recommendation, walk your applications down to important people in law schools. When you work for tribal governments, your recommenders tend to be people who are, to most law schools, completely anonymous, and they don't pay much attention to people like that. But the great thing about being somebody who's worked for tribes is that you come to these things, this scholarship, and this thinking with, I think, a dramatically different perspective than if you worked for a big firm doing appellate litigation. I worked for many years working with tribes where I got to see my client all the time. I got to see my client way too much. I still remember my first job at the Passquayaqui tribe, and my phone would ring and 050 chairman would come up on the digital screen, and I knew that it was client time. So all of this is to say that I've had so many conversations with clients who are elected tribal leaders, who are high-level tribal government officials, who really do the real work in Indian country, asking me why it is we can or cannot do something as a tribal government. And Frank Edwagishik, who is a longtime chair at the Little Traverse Bay Bands of Odawa Indians, is a mentor to myself and my wife, likes to tell a story about how his attorneys, Indian law professors, had been telling him for years, you can't prosecute non-Indians because the Supreme Court says so. And I never really agreed with him. His response to that was, but basically he said, we can do whatever we want if we're a sovereign entity. There are always limitations to what the client thinks they can do. But the point was important. The point is that if you're going to govern, you better govern. And I've always taken that very seriously. So the theme of this introductory commentary, I guess, is to say that we need to be creative. We need to be expansive in our thoughts. And interestingly enough, I look back upon somebody like Rennard Strickland, who actually was that person. His writings from the 70s were sort of the prototype for what I do now. He wrote a book called Fire and the Spirits, which is about Cherokee customary law. And nobody was writing that in the 70s, and very few people to this day write about the customary law of Indian tribes. It's becoming more fashionable at this point, but he made it possible to think about a tribe's culture, a tribal nation's culture, and how that culture is linked to modern day law. So this area of creativity that I want to talk about, there's actually two of them. I'm only going to focus on one. The first is tribal law. And as I said, Rennard sort of paved the way. He once wrote in one of his books, and I can't give you a citation, about how the business of tribal government, tribal sovereignty, throughout most of the 20th century was about survival. It used to be, and I don't know if he said this part, but I'll say this. It used to be that if a tribe went to the Supreme Court and lost, that was probably the end of that tribe. Every Supreme Court case involving an Indian tribe well into the 20th century was truly an existential moment for that tribe. You ever heard of the Teton Indians? They lost their Supreme Court case. They were not actually a tribal government. That's not a good example, but it is an example of how you can lose a case and it would gut that tribe for a long time. Now tribes go to the Supreme Court and they lose and they pick themselves up and they figure out a way to get around the decision they lost, which is one of the things that you find yourself doing when you're in-house counsel for Indian tribes. But Rennard said that the future of tribal sovereignty is more bureaucratic. Tribes are really federal government contractors now. We do a lot of things dealing with the federal government. We negotiate what we call 638 contracts, annual funding agreements with the federal government every single year. Congress appropriates a certain amount of money and tribes receive that money, and if they have the capacity and willingness to do so, exercise their sovereignty to determine how to spend that money. So that's sort of one area that I've written a lot about. More and more people are starting to pay attention to as a matter of legal scholarship. But it is really the business of modern tribal government. The other area is something, and this is what I'm going to talk about today, that I frankly have not given any respect to whatsoever. And it's the area of international customary law, primarily the United Nations Declaration on the Rights of Indigenous Peoples. For somebody who started their career grounded in what tribal law is about and sort of the outer contours of how tribal law is affected by federal Indian law, even by the Supreme Court, even though I like to ignore them. That's part of the future, but another area is something, like I said, I've ignored, and I'm going to try to delve into why I think and how I'm planning on sort of developing that in my own thinking on that. These areas are the dark matter of federal Indian law. What is dark matter? It's on your cover. That's what dark matter is. Dark matter is this weird thing that exists, and it's hard for me to believe that physicists and astrophysicists take this seriously, but they have this idea that there's all of this known observable universe that we can see, even if we can't really see it, but theoretically we know it's there. Planets, stars, space dust, even like quantum things like light. Those are all things that have a tangible weight to them. And scientists think that they can weigh all of this matter. And they observe the universe and how everything moves around in the universe, and they take the matter that they know exists, and it doesn't make sense. That there's gravity out there that nobody can figure out what the source of that gravity is. And depending on what you read, I mean, go on Wikipedia and just Google dark matter, because that's all I did. Something like 70% of the matter of the universe, and that's a made-up number, but something like 70% of the matter of the universe isn't observable. Scientists can't figure out where it is, dark matter or dark energy. So it's hard for me to believe, as a distant observer of all this science, I'm interested in reading this stuff, that this is a real theory. They don't know where this matter is. They call it dark matter. I think the same is true for areas of federal Indian law as well. There are parts of federal Indian law that we have not yet really observed, that we haven't theorized yet. And I'm hoping to offer a theory, because it takes a theory to beat a theory, as to an area of federal Indian law that has always troubled me. And that area of federal Indian law is the scope of the duty of protection, which is usually referred to in the modern era as the trust responsibility. The trust responsibility is the relationship between Indian tribes and the federal government. When a tribe enters into a treaty, and we heard about treaties that are related to this location here, when a tribe enters into a treaty is really a contract. So each side gets something from the other in return for one thing, or whatever thing that is. So the tribes typically, and I know this is true here in Oregon, it's definitely true where I come from in Michigan, gave up lands primarily, vast amounts of lands, and the resources on those lands, almost all of those resources as well. In Michigan, my tribe executed a treaty with a bunch of other tribes in 1836 in which the tribe gave up millions of acres of land for, on average, about 12.5 cents an acre, which back in, even in 1836, was a pittance compared to the value of that land. So in exchange for giving up all of this land and all the resources on the land, in exchange for that, we got an illusory promise for a permanent reservation. That didn't happen. We got the promise of tribal sovereignty. By the fact that the United States entered into a treaty with an Indian tribe is a meaningful thing. It's an acknowledgement of a tribe's nationhood, of its sovereignty. So that's something. The tribe also got something known as the duty of protection. Now, what is that? Well, part of the duty of protection we know about. So one of the things we get from the United States as part of this duty of protection or trust responsibility are all of the federal appropriations I just talked about. You can monetize that. You can actually quantify that and say, well, this tribe gets, I don't know, $500,000 from the federal government based on a choice made by Congress, a political choice, to appropriate that amount of money to the tribe. And a big part of the business of tribal government is figuring out how to spend that money. And usually the tribe negotiates with the Department of the Interior or the Indian Health Service about how to spend that money. So if you're getting about $500,000 a year, or even if you're getting $25 million a year from the federal government, and every tribe has a different dollar figure, it's all a choice that Congress makes as to how much that is a pittance. That is nothing compared to the thing that tribes offered in exchange for that duty of protection. So I said my tribe got 12.5 cents an acre, and then we sued the federal government under the Indian Claims Commission and got a few $1 million more. But overall, I would say the 6 or 8 tribes that signed the 1836 treaty, only 5 of them are federally recognized now, and only in the last few decades. Got a few $1 million in exchange for all of the land, 1/3 of the land of the state of Michigan. In 1836, when the tribes signed that treaty, all of the land that was at issue, the ceded territory, was covered by old growth pine, white pine, some of the most valuable timber ever in the history of the United States. And nobody knows how much timber that was. But I'm going to tell you a number that I just made up. I'm going to say it was worth $1 trillion, because why not? It was. It was worth so much money, an infinite amount of money. There are buildings all over the country that had the wood inside of those buildings, probably not here, but in the east side of the U.S. and Canada, overseas, that come from what is now Michigan. There are logs that sank during storms in the Great Lakes that people still go down and pull those logs up from the 1850s, bring them up and sell them for millions of dollars each. That is how valuable this old growth pine timber, primarily it is worth to this day. And that's just the timber. It doesn't count everything else that the tribes gave up that is the value of the land, that anything you can do with that land. The Upper Peninsula used to be one of the richest copper deposits in the world. And we sold that for 12.5 cents an acre. So it's more than the United States can ever pay or ever will pay. Although, to be frank, if they can come up with $1 trillion every year to get people to go back to work after COVID, they can give the 1836 treaty tribes $1 trillion. I would take it if I were the tribal leaders. It won't happen, but that's about right. It really is that much money. And, there's a reason why treaty rights don't get abrogated by Congress. because treaty rights are, the value of them is almost infinite for every tribe. There's a thing called the Takings Clause in the Constitution that says if you take a vested property interest from somebody in the United States, the government has to pay just compensation. Well, how do you value just compensation, say, for hunting and fishing rights of a given treaty tribe? How much money does the tribe here in Oregon make every year from hunting and fishing? Take that number, call it X, multiply it by the rest of time. Or as what Charles Wilkinson used to say, until the lands are, I almost said until the lands are required for settlement, because that's what we say in Michigan, but you know, as long as the grass grows and the rivers run, which given climate change maybe is only another decade or so, but it's going to be a lot of money. So treaty rights are so infinitely valuable. The value of these treaties is beyond anybody's real comprehension in a meaningful way. So tribes got something in exchange for those treaties, for the cession of that lands, that has not and never will be repaid. So that's part of what I mean to say when I talk about the dark matter of federal Indian law. Congress, at any time it wants to, could fulfill its treaty obligations. They could fill in the blanks on what is the trust responsibility, but they don't do it. Let me give you an example. Congress could pass a law right now saying the United States government guarantees law and order in Indian country. Here is half a $1 trillion divided amongst all the tribes to guarantee enough police, enough rehabilitation, enough social services, jails, tribal courts, everything you possibly need to reduce the crime rate in Indian country. Congress could do that right now. That would be partial fulfillment of the duty of protection. And after they did law enforcement, they'd have to do housing. Indian country has the worst housing in the country. You could pay for that. Congress absolutely could pay for that. When tribes signed a treaty and said, we're giving you all our land in exchange for the duty of protection, tribes were expecting the United States to provide law enforcement. Some treaties even said, protect us from the whites. Some treaties said, in exchange for all of these lands and a restriction on our sovereignty, we expect housing, we expect health care, we expect environmental protection. We expect protection from those American citizens around us, literal protection, because places like California and probably here in Oregon too, white citizens used to exterminate Indian people, massacres all up and down the West Coast. These things happened in Michigan as well. In 1900 at Christmas, the sheriff of, I forget which county because it's the colonizer's name, but burned down the entire Indian community of the Sheboygan Band, which is now known as the Burt Lake community. Burned it to the ground, killed a bunch of people, forced them out. Call it the Burt Lake Burnout in Michigan. It wasn't a massacre as dramatic as some of the things that happened in Indian Island off of Humboldt County in Northern California, but still pretty dramatic. These are things that the United States owes Indian people and tribal nations that they have not ever fulfilled and probably really never will. So why is it that this is a case? Why is it this is the case? Why can't an Indian tribe just sue the United States and say, provide us all this stuff? And I won't go into too much detail about it. People are going to start yawning. If you've taken federal courts, and I saw some of the students are taking federal courts right now, that whole book, Federal Courts, this thick, is about how to keep people from being able to sue the government to effectuate their rights. That's the whole point of federal jurisdiction. There's sections in there about sovereign immunity. Sovereign immunity doesn't even exist. It's not even a word in the United States Constitution. Half of federal jurisdiction is about sovereign immunity. It's totally made up. Although Hamilton did write a Federalist paper, like number 87 or something, 82, about sovereign immunity. And it's the reason I don't like the Hamilton play, because there's nothing in there about that Federalist paper. So tribes can't sue the United States. The federal government is immune from suit. And on a more deeper theoretical level, the way the Supreme Court and the President, the executive branch, and Congress talk and think about each other, they have this thing called separation of powers. And the way the Supreme Court, from day one of the United States Supreme Court, going all the way back to the very beginning, believes that that the court, an Article III court under the Constitution, cannot order Congress or the president to do anything affirmatively. The court cannot issue an opinion and an order to Congress saying, fund Indian country law enforcement. No matter how important it is, no matter what the treaties say, no matter what the United States has promised, no Supreme Court justice in the history of the Supreme Court, and I'm trying to think of any crazy justices who might have done it. Maybe Douglas, if he was deep into his cups way up in the mountains in eastern Washington, might have done it. He tried to enjoin the Vietnam War after all. But even he probably wouldn't have done it. No justice of the Supreme Court ever would have ordered Congress to fully fund Indian country programs because of separation of powers. And that's baloney, but this is the problem we have to get past. So, how are we going to get past all of this? Well, we need to recognize a couple of things about the Constitution that are real things. And for the most part, the reason we don't recognize these things is because the United States Department of Justice tells the Supreme Court not to pay attention to those things. What are those things? Number one, the Constitution has a waiver of sovereign immunity in it. Actually, it has two. People don't pay much attention to this. There are two waivers of sovereign immunity in the Constitution. You could sue the government for two things. One is, if you're in jail and you're innocent, you can file a petition for a writ of habeas corpus. And there's a legal fiction that we can somehow limit your habeas rights, and I'll set that aside. The other one is something I've already mentioned. It's the takings clause. You could sue the government when it takes your property, your vested property interest. You can sue them for money damages. That's a waiver of sovereign immunity. Every American citizen, foreign nation, anybody who is in the United States has a right to sue the United States government, and usually by extension, state governments, when they take your property. You know who does not have that right because the Supreme Court says so? Indian tribes. Why don't Indian tribes have a Fifth Amendment right to sue the government for money damages? Because the Supreme Court said so. Because the Department of Justice persuaded the Supreme Court that Indian tribes are different, that under a duty of protection, or what back in the day they called a guardianship, Indian tribes are subhuman, and they actually don't have the right, like other people do, to sue the United States government. Now, we've moved past that, you would think, at least by the 1970s and 80s, where the Supreme Court stopped saying Indian tribes are subhuman, that they're children under the guardianship of the United States. Sometimes they say it when they're in a bad mood, or Justice Thomas is writing the opinion, but mostly they say things like Indian tribes have a trust relationship with the United States, and it's a much more government-to-government type relationship, and that's all a good thing. But they don't go back and fix the things that the Supreme Court did when it was saying that Indian tribes were subhuman children who were under a guardianship. So that's one thing. Indian tribes should be able to sue the United States for money damages just like everybody else when the United States takes the property rights of Indian tribes. The other thing is, and this isn't that big of a deal, but people in the United States, including Indian tribes, can sue the United States government to stop them from doing something that's illegal. It's called an injunction, and we don't need to get too much into that detail. But with these two legal tools at your disposal, if you're a tribal government, the right to sue for an injunction for when bad things are happening, to stop those bad things, and the right to sue for money damages, then you should be able, a tribe should be able to fully use the court system to effectuate the duty of protection. So, how do I get to that point? How does a tribe theorize, using its creativity, think about how it's going to get into court to do that thing? Well, one way I think, oh wow, I have a bracelet, a necklace on. This is beautiful, by the way. One way is to think about the United Nations Declaration on the Rights of Indigenous Peoples. A little background, about 10, 15 years ago, the United Nations did this thing, we call it UNDRIP. Everybody thought it was amazing. Almost every government in the world, except for 4, totally jumped on it. The nation of Mexico has incorporated it into its constitution. Other nations around the country are taking it seriously. And there were 4 that said no. They were the settler colonial nations that came out of England, Canada, the U.S., New Zealand, and Australia. Then after a while, Canada said, well, we will go along with UNDRIP. We hate being pariahs. The United States is fine with being a pariah, but we don't like it. We want to project the image that we're nice, you know, Canadian nice. That's a lie, but they want to project that image. And the rest of the world wants Canada to project its image of being nice. We bought into that. Same with Australia and New Zealand. And it just left the U.S. And finally the U.S., with Hillary Clinton as Secretary of State and Barack Obama as President, said, yeah, okay, well, we're the only ones left, so yeah, we support UNDRIP. And here is, by the way, is a 50-page memorandum explaining how actually we don't support any of this stuff, and we're rejecting almost all of it. But don't read that part, just read the announcement that the President's going to make. And this is the reason why I paid so little attention to UNDRIP. If you went to the Supreme Court now or any federal court and said, well, UNDRIP says the United States has to fully fund a environmental protection unit for an Indian tribe and points to an article in UNDRIP, the court probably will sanction you for lying to it or coming up with a frivolous argument. They won't sanction you, but they'll completely ignore it and mock everybody for thinking that international law controls what happens in the United States. Well, here's why I think we should actually pay attention to UNDRIP. I'm past that now, and I'll give you a couple of reasons. One is federal Indian law is all about international customary law from the very beginning. Everything that happened in the first century of federal Indian law is all about international customary law. We hate it, but you ever heard of the doctrine of discovery? It's Johnson versus McIntosh. That's all comes from international customary law. You know what else comes from international customary law? And I have Seth Davis and Eric Bieber at Berkeley Law to thank for pointing this out a year or so ago to me. The canons of construction. The notion that if a superior sovereign or a bigger, more powerful sovereign, I don't mean morally superior because I sure as hell don't mean morally superior, but a bigger sovereign takes a smaller sovereign under its protection, this is the duty of protection. And the interpretation of that relationship, usually reduced to writing in a treaty or some sort of other agreement, if there's an ambiguity in that written agreement, it is to be interpreted to the benefit of the weaker sovereign. That was something that predates the U.S. Constitution. That's something that the founders of the Constitution were talking about publicly when they adopted the Constitution. That's something the founders were saying, well, around the world there are these inferior sovereigns under the protection of superior sovereigns. They have canons of construction for their agreements. We support this. We're part of the international community. We'll do the same thing. And they did it with Indian tribes right away, and they had been doing it all along. So the canons of construction come from international customary law. Why is this important to UNDRIP? Because I think that UNDRIP is the modern day manifestation of what the international community believes is sort of the baseline rules for the duty of protection between any bigger sovereign and a smaller sovereign. So it's not the greatest thing, but it is sort of a written down memorialization, a manifestation of what the duty of protection would look like in the absence of a treaty or some other agreement that would fill in some of those gaps. Think of Indian treaties. We talked a little bit about them already. They tend to be really short and to the point and succinct. So the treaty that I've been talking about today with Michigan, the 1836 Treaty of Washington, is a land cession treaty. And then 70s, our big treaty rights case, U.S. v. Michigan, wasn't about the land at all. It was about the Great Lakes and who could fish in the Great Lakes and whether Indian people who were beneficiaries of the treaty could fish in the Great Lakes without regulation by the state government. And the tribes won that case. Actually, the United States won the case, but the tribes are the beneficiaries of that case in U.S. v. Michigan. And the reason we won is because the treaty said nothing about fishing on the lakes. And if the treaty is silent about a given right or a property interest that tribes possess, like the right to fish, then the treaty doesn't impact the right to fish. And that's why we retained the right to fish. And later on, in a series of consent decrees, another one's coming up here real soon, we've agreed sort of in a new treaty to modify that right to fish on the Great Lakes to some extent. And that's all a good thing. That exercise of sovereignty, I have nothing to say about that. But All of that is to say that that's one aspect of a treaty that is completely codified. It is settled in this area. But there are other aspects of the treaty that are implied. There's this relationship, the duty of protection, is not fully manifested in this treaty. And if it's not in there, and an Indian tribe expects it and understands it to be part of the trust responsibility or the duty of protection, then it absolutely should be there. A tribe, and tribes have been doing that for a half century now, actually more than a century. The original treaty rights cases are winter's rights cases. They're water rights cases. And many treaties out here in the West don't say the tribe has enough water, has the right to water for a certain amount of practically irrigable acreage, right? That's not in the treaty, but the treaty creates a homeland. The treaty creates the right of a tribe to live in its traditional territories, sometimes in a shrunken version of that, but that is a homeland. And a homeland doesn't mean anything unless, here in the West especially, there's water. And in Michigan, you don't have a homeland, we have lots of water, so that's a good thing. We have water, but if we don't have the right to hunt and fish, to gather, to move around, to do our cultural teachings, to do our religious exercise, and also our agriculture and our international or sort of trade relations, then our homeland is meaningless. All of those things are implied in the treaty. The point is that if the Supreme Court could acknowledge international customary law in creating the fundamental principles of federal Indian law, that tribes have, that treaties and statutes are to be construed to the benefit of the tribal groups, that Congress, if it's going to take away tribal powers, must come right out and say so in a clear statement, that states do not have, state law has no force in Indian country absent the consent of a tribe or to a lesser extent Congress. These are just examples of principles of federal Indian law that all come from international customary law at the time of the treaty rights, that the treaties were negotiated. Now we have a modern manifestation of what people understand, international law community understands as the duty of protection. So what should happen, and I'll write the paper, and nobody will pay attention to it, but you have to pay attention to it because you came to me tonight to listen to this. What an Article III court is absolutely authorized to do, if a court is persuaded that that is the case, is to issue an injunction against the United States whenever it is underfunding a program, whenever it is doing something that it's not supposed to do, and in the absence of the government's compliance with that order, to order monetary damages to be paid by the United States government to compensate the tribes for the failure to comply with that aspect of the duty of protection. Now, right now, when tribes bring suits for money damages against the U.S., it's for things like, Navajo has a great one. A friend of mine named Dan just argued a case in the Court of Federal Claims in D.C. I just saw him last week. And he said the claim there is for $40 million. And when you sue the United States and you ask for $40 million, the Department of Justice drops every nuclear bomb it can possibly on you. The whole point of the Department of Justice is to keep Congress free and clear of ever having to pay any money for anybody for anything it's ever done. And when a court says, well, you have to pay $40 million, that the Supreme Court, I guarantee you the Supreme Court will review that case. It is so important to the national government, to the American taxpayer, I suppose, to review those cases. But I'm going to be talking about if the Article III court, the federal judiciary, is absolutely empowered, and not only empowered and authorized, but obligated to effectuate the duty of protection that is contained within Indian treaties and other agreements between tribes and the federal government. $40 million is nothing. It really is nothing. We're going to be talking about billions and billions of dollars. And that's where I'm going to stop, because that's where this is all heading. And all right. One last thing. I already said everything, kind of everything I was going to say about Rennard Strickland, but Rennard it is such an honor to be here in his name. I met him only one time. He was the keynote speaker many years ago at the Federal Indian Bar Association meeting Albuquerque, back when it was at the Marriott, so this is a long time ago. And I had an opportunity to introduce him, and I just had a prepared script. But for about 10 minutes, I sat up in front of on the podium with him and just talked with him. And he was the most delightful person, I think one of the most delightful people I've ever met. And the great thing about him, and this is one of the reasons I do comic books, is that he said, right now, all I'm doing is writing kids' stories, children's books. And I said, everything I want in the world is what this guy has right now. So one day, that's my goal. My career path is to become Rennard Strickland. And with that, thank you very much. Very happy to answer any questions you might have, so hit me. Or I'll have to call on people. I'm going to start with Maddie, and don't do it to her. And all I'm going to say is, Maddie, ask me a question. Go ahead.
My question is, when you're looking ahead at litigation strategies and so forth, how ominous do you find what happened in the court last term with Castro Huerta, this new theory of Indian treaties, and maybe there aren't any, or maybe we didn't clap our hands and they all died. I found that very disturbing, but I'm not in the field.
That's a great question. What does Castro Huerta mean for Indian country going forward? The facts and the pure legal issue of Castro Huerta to me is not that big of a deal. I really think that the Supreme Court had a little bit of a turnover from when it decided the big McGirt versus Oklahoma case, and Oklahoma filed something like 60 cert petitions, all demanding the court, now that it has ACB on the court, to overrule McGirt immediately. The court couldn't even do that, so it threw Oklahoma a little bit of a bone. So now Oklahoma can prosecute non-Indians who commit crimes against Indians inside of Oklahoma Indian country. Okay, and that's going to be an issue for those tribes, definitely. Does that extend out to the rest of the states of the Union and the tribes? It does, in theory, but almost everywhere else, and Justice Sotomayor actually said this in oral argument, no state's going to actually want that jurisdiction if they don't already possess it, because it's an unfunded mandate. It costs a lot to prosecute people, and you know what else it costs a lot is to put them in jail. That is like the biggest expense of many state governments, is putting people in jail. And so I really don't foresee a practical consequence to anybody in Indian country from Castro Huerta, except in Oklahoma. And even there, the tribes have already paved the way for stepping in the shoes of the local governments anyway. So I don't know what the impact's going to be. We'll have to follow up on that. Now it matters who writes the opinion, and we learned something because Justice Kavanaugh wrote that opinion, and it reads like something that the Chief Justice Rehnquist would have written in the 70s or in 80s, or something that maybe Scalia would have written, although he didn't write very many Indian law opinions. It's got broad pronouncements about what Indian law is all about. It's rejecting things based on loose supposition about broad principles of Indian law that go all the way back to the founding of the Constitution. It's got a funky legal history that doesn't make sense. These are things that the Supreme Court routinely did throughout the 60s, 70s, 80s, into the 90s. They don't generally do things like that anymore. So I don't know. I don't really care that much about Castro Huerta. I could be wrong, but I think it's kind of a nothing burger. What really scares me about this Supreme Court is the abortion case. That shows to me that if they're in the mood for something and they got 5 votes, they will do absolutely anything they feel like it. There are no restrictions. The only restriction on this Supreme Court is impeachment, I suppose death, although I don't wish that on people. Impeachment, or that's it. And they're not going to get impeached. I mean, if Donald Trump he got impeached, but he didn't get removed. None of these justices know that nobody can touch them. They are untouchable. With 5 votes, nobody can change them. So that's the concern, is that they don't even have to try very hard anymore. They did the big thing. They got rid of the right to abortion, as acknowledged by the Supreme Court earlier in Roe v. Wade. And now it's just like gravy. They can do whatever they want. It's almost like, now we'll just get rid of affirmative action in higher education. So they'll do that. I mean, they've got political commitments that they have to fulfill. But there are no restrictions on the court. There's 5 justices for a vote. They're God. Absolutely no restrictions. So if they casually feel like getting rid of the Indian Child Welfare Act and they got 5 votes, they'll just do it. It could be a short opinion. They don't have to justify themselves to anybody. That's what concerns me about the court. Who's next? You had a question right next door, or?
Oh, I teach water law, and so I'm so interested for you to talk about how you see the water rights settlement process that the federal government uses and the litigation, the different litigation strategies tribes have advanced in trying to protect their water rights in this UNDRIP international customary law context, because it does have these deep roots in winters that sort of connect to this international context. So I don't know if you have additional thoughts about that water rights context.
Yeah, again, I'm from Michigan, and
Right.
we have the privilege of not really having to deal with a lot of this stuff. So I look at it from afar. I think of the water rights settlements out here, the litigation out here is a 2-part process. There's the law, right? And UNDRIP plays into that. But the treaties establish a homeland. The treaties establish a right for tribes to have access to hunting and fishing, agriculture, travel. All of that stuff requires water. So there's a pretty well-worn, established, I mean, it's totally made up and glommed on top of treaty rights, but it's the winter's rights, it's Arizona versus California, practically irrigable irrigation, all that stuff is the law. But that never settles these cases. There are too many parties, too many non-Indian, non-tribal government interests at play. Sometimes these cases have thousands and thousands of parties. You know, the Snake River adjudication in a tiny little courthouse, probably smaller than, I imagine it's smaller than this room, with 500 lawyers standing outside all waiting for the right to come in and speak. I mean, the whole thing is comically ridiculous. And no matter how many court orders you get from judges trial level, state Supreme Courts or federal courts, even the U.S. Supreme Court, it doesn't actually resolve the finality of these cases. They all have to be resolved by settlement. And that's where the political action comes in. And the political action is, and tribes tend to actually prevail on a lot of this, if they can get Congress to appropriate the money, is Congress buys out all the non-Indians. And they give them money and make them go away. And last night we were talking about the place where, I keep pointing to poor Maddie, she's horrified by this, but Maddie's from Klamath River, up in the area in Oregon, where the Klamath tribes are. And there's just this, the tribal right to access to water, not just Klamath, but all the downriver tribes, and the farmers presuppose ostensible right to have that water, even if it kills everything downstream, so they can do farming. And Congress will resolve that someday by buying out one or the other. And I don't think it's going to be the tribes. You just buy out the farmers. And it's going to cost an ungodly amount of money. But guess who has the right to print money anytime they want to? It's Congress. So that's how these things get resolved. That's the political angle. And, you know, there's every Department of Interior secretary for the past half century has complained, well, Congress ratifies these agreements, but then it doesn't appropriate the money. That is a problem. It's a political problem, really not a legal one. That's just my sense of all these things from afar. I had Kevin Washburn at Michigan State Law School many years ago as a keynote speaker for our conference with the Tribal In-House Counsel Association. And we were in the hallway, and he was complaining as Assistant Secretary, you know, Congress agrees to all these, ratifies all these water settlement agreements, but there's $1 billion they owe all these farmers, and they're not paying it. And actually, I think what he said, yeah, it was $1 billion. And I said to him, kind of facetiously, but I was being serious, like, guess how much the Black Hills are worth? About $1 billion. You know, you actually have $1 billion in a trust fund that's owed the Great Sioux Nation, whatever that is, and take that money and give them back to Black Hills. All done. And he's like, oh, that'll never happen. I was like, it could. It's all political will. Other questions? Go ahead, way in the back.
On the subject of the Black Hills, I was looking at the map of that the other day when we were talking about that in our Indian law class. And one of the things that occurred to me about the Black Hills is that there's an awful lot of national forests there that wouldn't even require a takings
That's right.
clause in order.
That's actually all I'm talking about. Yeah.
Is there what's, other than politics, of course, is there anything else that would be standing in the way of that, or could Congress just do that?
Well, again, I'm from the East. I'm not really a public land scholar, but from my perspective, Congress could pass a law and give all of the federal public lands. I mean, in some respects, in Michigan, for example, I talked about our treaty right to fish in the Great Lakes, but we have rights inland as well. We call them inland rights, and we exercise them on state and federal public lands. We're already there, and it really wouldn't be that much. It's just political will. There's no private vested property interest in the state and public lands, although the screaming from all of the people who want to go on those trails will be heard for the next century, but I don't care about that. Sorry, all you hikers. But, I mean, think about it. So much land out in the West, and you have all these conservative ranchers saying, I hate that the government owns so much of this land. I have a solution for you. Give it to the tribes. It's theirs anyway. Then they won't like that either. But there was another question?
Yeah. Thank you again for being here with us. You mentioned something that Professor Arnett has mentioned several times. Over the last, and you might have mentioned this earlier this morning, over the last several decades, it hasn't been so much the executive or the legislative branch that are a problem for tribes, it's the judicial branch. Lately, especially, as we mentioned, the rate being returned, and then Professor Amos just mentioned water. So that's a concern I have as well in the Southwest. I'm lucky enough to be working for an environmental water law firm. And I know for a fact that out in the West, and especially the Southwest, there are lots of special interests who would like to see winners be overturned. You actually mentioned something this morning that really surprised me, that Senator O'Connor had a written opinion. So that's just crazy.
Yeah.
So the fact that the court just doesn't care and is at this point willing to do whatever it wants or whatever the interests want really worries me.
It should.
So, I'm worried that there's really no answer to this question. How do we fix that? I mean, we were just saying death, anyone death, impeachment. How do we fix it other than just slowly teaching people about why it's important to nominate people that actually care about thinking about it rather than just serving special interests? What's the way to fix this problem?
I think you do what Indian tribes have been doing for a long time now, is that you don't let the Supreme Court have your cases. So the great thing about Winter's rights, and this is very limited, this is unique to Winter's rights, is that those cases are not justiciable. And what I mean by that is they're too big. There's too many people. No court has the capacity to really handle all of that stuff. I doubt Congress does either. But over the course of decades, all of the parties can reach some sort of awful agreement that everybody hates and try to reach some finality. And it has to be ratified by Congress to actually be final. But the great thing about that is that you'll never have an SOC opinion like that. That's the last one. That's the last time the court ever took a really big general stream adjudication on appellate review. Wyoming versus U.S. was that case. And once in a while, they'll handle things that show up in the court's docket as part of its original jurisdiction. Arizona v. California is still an open, possibly pending case. But they're never going to be able to handle it in the first instance. They're never going to be able to want to take that case. And the great thing about Justice Blackmun is that he put his papers online as well. Thurgood Marshall is the one who made that opinion, the draft opinion, available in the National Archives. But Justice Blackmun had memos from his clerks, And his clerks, for years leading up to the Wyoming v. U.S. case, were asking their justice, why does SOC care about this water rights case so much? And you start seeing pattern that even within the quiet, secret institution of the court, everybody in the court knew that she had a conflict of interest, and she was angling for some vehicle to get rid of winners' rights because it was going to be incredibly financially beneficial to her family. And when that moment finally came, somebody, we don't know, no idea what happened. Somebody must have said, you can't do that. So I don't think there's a real vehicle to go after winners' rights. I mean, you're going to still have wins and losses in the lower courts, and those are going to, the losses are going to be really bad and they're going to be really hurtful. I don't see winters itself going away in any real meaningful way. It might be limited, it might be restricted in some way. I just don't see that happen. There's no way for the court to take a case like that anymore. But outside of that context, all bets are off, right? Any case can be adjudicated, and the court does not care, really. So I don't think they do that for winters. But there are other areas they absolutely, all the bets are off. Other questions? Okay, go ahead.
Yeah, you said earlier in your talk that the Rincon case, the Elwha case before the court now, has a potential to wipe out Indian law. And two of the three arguments made by Texas and the Rincons, could have that effect: the authority of the Constitution, the legislative imperatives, and equal protection claim. Leaving just this 10th Amendment anti-commandeering claim, which I'd never heard of the anti-commandeering doctrine until Rincon came around. Which way, Professor asked.
I wish I'd never heard.
Well, yeah, that's it. So they could do that, and they've done it in Roe, something really dramatic.
Mm-hmm.
Do you think they really will do that, or will they opt for the anti-commandeering basis to toss a bone to anti-Elwha people, which we could survive?
So, we talked about this in your class this morning. So there are these constitutional issues in the challenge to the Indian Child Welfare Act, one of which is, does Congress have the power to enact a child welfare code just for Indian people? Does Congress just have that power under the Constitution? And relatedly, even if Congress did have this power, does it discriminate? Does it create a racial classification that violates the Constitution in terms of race discrimination? If the answer to either of those questions is yes, it's really an existential threat to everything that we understand in federal Indian law. Congress's ability to pass legislation shrinks down dramatically in terms of just its power under the Constitution. But if Indian law really is a bunch of racial classifications rooted in Indian status, then every statute Congress passes potentially is subject to strict scrutiny. And a lot of that stuff will go away, because we know strict scrutiny is strict in theory but fatal in fact. So there is a third theory which gets a lot of play, called having to do with the 10th Amendment, which is a states' rights amendment. What we know is that the Supreme Court has held in the last few decades that Congress cannot commandeer the legislative prerogatives of states. So Congress can't order states to do something because it's Congress and it wants the state to do something. That's commandeering, and that's unconstitutional. By the way, the reason you've never heard of that before is because it doesn't exist. It's made up. There's nothing in the Constitution about commandeering. But the court is a federalism court. They have states' rights judges on there. And they have to give some meaning to the 10th Amendment, and that's the meaning they chose to give to it. The Indian Child Welfare Act tells states what to do. It runs it through the state judiciaries, though. And it says, state courts, before you terminate parental rights, you got to make sure that the agency does certain things. So it's really wildly amazing how Congress was prescient in 1978 about commandeering, because it didn't exist in 1978. Commandeering does not show up in the Supreme Court reports until 1990 in New York versus U.S. and Prince, which is another case from like 91 about commandeering that the court said was also federal commandeering of state legislatures. So for them to route everything through a state court is smart. The reason that's smart is Congress absolutely can commandeer state courts. It's not what it is. Congress creates a right under federal law, and state courts have to enforce it. Here the right is you can't terminate an Indian family, one of the rights, but one good one is you can't terminate the parental rights of an Indian parent until you've provided, the state court finds that the state has provided active efforts to try to prevent the breakup of that Indian family. And so what the Supreme Court may say is that the active efforts requirement is commandeering of the state. It's not. But even if they do say that, it's a limited problem. And Congress could actually fix it real easy through something called the spending power. It's like the secret fix to commandeering problems. You can't commandeer and tell the states what to do, but what you can do is say, here's a carrot. If you want this carrot, do what we want you to do. And the example that the Supreme Court, where they invented this, again, they had to invent this because they invented states' rights in the first place, is federal highway funding. So those of you in the West, you're close enough to Montana to remember when there was no speed limit in Montana. Montana rejected the federal highway funding because federal highway money because they wanted to have a speed limit that was called necessary and prudent, or no, reasonable and prudent. That was the speed limit in Montana for many years. But every other state accepted the federal highway money and dropped their speed limit down because that was the condition. So that's the way to fix commandeering. So that's why I think if the court doesn't want to throw all of Indian law out, then they'll just, but they have a political commitment to those, sort of the conservative social constituencies like, evangelical Christians, adoption, even like abortion, anti-abortion rights people. All of them are arrayed against Elwha. And if they have a political commitment to them that they want to fulfill in some way, but not destroy all of Indian law, then strike some of Elwha down under the 10th Amendment. That's okay. We can fix that pretty easy. I really do think that. That's the best possible scenario. And I think the only person on the Supreme Court who would go down that road is the Chief Justice, because he did it once before with Obamacare in a totally different context. He's also somebody he's not crazy. I don't know if you guys knew this, but he sort of semi-dissented in the abortion case because he said, I hate abortion just as much as you do, but we don't have to do this today. We have an election coming up that the Republicans were going to roll all over the Democrats. They probably still will in a couple of weeks. But, the abortion case gave the Senate back to the Democrats, at least for a while. At least it's up for grabs. And the Chief Justice, the justices say they're junior varsity politicians, but they're still politicians. He's not crazy, but the other ones are, some of them anyway. As my friend Leah Littman at Michigan Law, she runs a strict scrutiny podcast. Her ongoing metaphor for the justices like Alito and Thomas is that they have the votes and they want to do everything right now. And it's the marshmallow theory. And have you guys ever heard of this? My wife hates it, and she's right. The marshmallow theory is that you put a marshmallow in front of a kid and say, don't eat the marshmallow, and in 10 minutes, if you don't eat the marshmallow, you'll get 2. And children who are, poor, basically, and hungry will just eat the one marshmallow right away, and they won't wait for the bigger thing to come along later on. And that's what Leah thinks of as the Supreme Court. They want that one marshmallow right now. And John Roberts is way more diabolical. He would be willing to wait so he can get both marshmallows down the road. Although I have no idea. Actually, none of that really makes any sense. But. Are we done?
Yeah, I think we're ready. Let's
Okay,
take
great.
the last question. Okay, thank you so much. That concludes our program for this evening. Please join us in the comments for some refreshments. Thank you all very much.
Yeah, sounds good.